Hello, everyone. Welcome to the show, to the Token City show. We are talking today with Andrew Bull. He is the founding partner of Bull Blockchain Law, and we're going to talk about tokenization in the US, in the United States of America, and regulation around that. Welcome to the show, Andrew.
Thank you for having me, and appreciate Token City for hosting.
Thank you. It's a pleasure to have you here, and I wanted for you to start by giving us an overview of the Genius Act, which made a lot of headlines when it came out. It's basically really solidified the change in regulatory outlook in the US, so to speak. So maybe you can give us a brief context on what the prior administration was doing and what changed with the Genius Act, and then we can continue the discussion.
Absolutely. So, definitely exciting times. This is really the first comprehensive federal legislation that we've been able to actually get through Congress in the United States. The Senate Banking Committee passed the Genius Act back last year, and now we actually have set clarity and definitions on how companies can issue stablecoins specifically. And that provides a significant amount of regulatory clarity here in the States because we had this massive disconnect in prior administrations between the banking sector and actual digital assets. And now we have a much more clear path for a regulatory approach at both the federal and state level that allows for companies to actually consider issuing stablecoins. So before it was a unified market, right? There was only a very few amount of companies that were issuing their own stablecoins. They didn't have a lot of regulatory clarity. A lot of legacy laws that existed had some clarity, but really not nearly enough. And so this federal legislation basically explains to issuers how to go about doing that in a compliant way so they can enter into the market.
Mm-hmm. Okay. And then the prior administration was doing something called regulation by enforcement, if I am correct. So, can you explain the difference between that at the time and, well, you just explained what the current framework, but can you yeah, give the
Yeah,
counterpoint?
absolutely. So specifically the SEC as kind of the prime example prior to this new administration was enforcing a analysis called the Howey test on most digital assets to determine whether they were securities. And so instead of providing regulatory clarity through legislation, they would basically wait for companies to act in the market and then go after them if they thought that they had broken some type of rule. Now, the issue with this, right, is that we don't get any actual regulatory clarity out of those individual decisions. And instead, it just created a market that a lot of companies, especially in the traditional financial sector, were extremely hesitant to enter into. So, right now, we have a complete opposite approach where the SEC, CFTC, other federal governmental agencies are now taking the approach that they're wanting the regulatory clarity to actually speak for itself and provide a pathway for these companies to go about being compliant. And again, before they didn't have that compliance roadmap, and as a result, would take risks in the market, issue stable coins, right? Create different types of digital assets and so on and so forth. And then always kind of have this lingering question in the background whether they were going to fall under the purview of one of the governmental agencies and then potentially be fined. There are many, many companies that ultimately entered into bankruptcy because they thought they were being compliant within the market. And then it turned out that the governmental agencies took a very adversarial approach to actually going after them. And it resulted in those companies becoming dissolved. And so now we have a completely flip 180, right? Like I was just kind of alluding to in the context of companies that can actually be regulatory compliant and not be massively concerned that, oh, maybe next day the governmental agency is going to come and knocking and say, oh, we're now going to investigate you for potentially violating these laws.
Yeah, absolutely. I mean, just launching something, a company, a service, not knowing whether it's legal or not, sounds crazy. But yeah, now the tide has turned, and we just went over the Genius Act. There's also the Clarity Act, which is being hotly debated by legislators. Can you tell us a little bit what the point of contention is, your view on it, and also whether this act called the Clarity Act, this bill, does go into tokenized securities at all?
Yeah, it's a great question. And one of the key concepts underpinning all of this is the Clarity Act is intentionally meant to provide clarity to governmental agencies as well as to market participants on exactly what definitions mean. So they carved out this new definition called a digital commodity, which basically says the SEC is not the actual governmental agency that's going to regulate digital commodities. In fact, it's the CFTC. And this was a point of contention before the Clarity Act even came into existence because companies would go out and issue some type of asset that potentially had some type of yield or some type of additional component to it from a rights perspective without necessarily having the clarity, whether this was going to be what we call a digital security or a digital commodity. So right now, one of the controversies is if you go out and create under, say, the Clarity Act, an asset that, for example, is stable or even maybe a non-stable version of it, and there's some type of yield component to it, are you creating what we call an investment contract on top of that traditional commodity, right? And that's an open-ended question from a regulatory standpoint. And the Clarity Act's main goal, at least from a motivational perspective, is really to carve out the exact assets that are going to fall under the purview of these governmental agencies so that these companies that want to go out and actually issue their own asset could theoretically have yield on it and might not necessarily fall into that digital security category like they would have under the previous administration. You know, Gary Gensler is pretty infamous for saying that all tokens that are created are securities. And this is really the anti to that, right? They're trying to carve out these two different categories, provide some explanation into how you go about issuing some type of asset that falls under that digital commodity so that you're not having the very, very strict restraints for how you can actually issue securities. Because at the end of the day, right, we have the stock market, right? We have regulated assets in publicly traded markets, and there's a whole regulatory component to that that the SEC oversees. But due to the unique nature of digital assets, right, we have a plethora of different examples that don't necessarily fit that traditional model. And as a result, if they can get this fully clear through the Clarity Act, then it's going to really open up a massive amount of opportunity for companies to be compliant, not worry that, if there's some type of yield that is controlled by the consumer base of the asset that they've issued, that the SEC is all of a sudden going to come and knocking and say that you're violating the Securities Act of 1933.
Of course. And on that note, do you think, I mean, there's a lot of talk around the Clarity Act. Do you think it's already having some sort of impact along with the Genius Act? Are you seeing some type of different interest among the people that call you for your services? What can you tell me in that sense about your hands-on experience on what you're seeing as of the current state?
Absolutely. So, having guided companies through the legal process since 2017, 2018 in relation to digital assets and whether they were securities, even now with the anticipation of these carve out definitions, there's a substantially larger amount of companies that were in the traditional asset space that are now coming into this space and adopting this new technology. And, that was a major hesitation for a lot of those businesses originally because they were basically viewing this as a potential risk, right, in the context of opportunity. And now, if we have clarity, that risk is kind of put by the wayside and actually has that clear path, like I was mentioning before. And so companies are coming in that maybe deal in traditional assets, right? Traditional commodities markets, futures, those types of contracts, and so on and so forth, in the context of not only financial products, but also potential investment rights products such as real estate, right? Real world assets, those types of opportunities are out there. And there's been a massive push now with traditional companies that are already operating in those traditional industries to now adopt this new technology because there is some of this clarity around whether these governmental agencies are going to actually come after them,
Yeah.
which is a massive, massive amount of help.
Of course. And yeah, and regarding the sectors, the industries that you mentioned, where are you seeing more interest, more renewed interest in the technology? You have mentioned a few, but are there any or one that stand out to you?
A few for sure. Definitely on the payment side, no question, especially with the combination of Genius Act and Clarity Act from a stablecoin issuer perspective. But now that more companies are issuing stablecoins, there's this whole additional market now, right, in regards to yields on stablecoins or in regards to how companies are building potential investment opportunities around stablecoins, for example, right? Because the initial motivation from a technological perspective was really to be able to process payments and or transfer assets in a very efficient and cheap way comparatively to the traditional market. Well, now what that has spawned is an additional market of companies that are going to be offering third-party exchanges, secondary markets, right, in relation to these assets that are stable and are payment based. But now we have a whole new breed of investment opportunities for individuals in the industry. And then in addition to that, like I mentioned, the real world asset area is definitely exploding from an issuer perspective. We have a lot more companies, both small and large, Fortune 500 companies that are publicly traded that have now started to the actual implementation of the process of adoption of integrating the technology into how they're issuing those assets. And as we see that kind of transformation of a lot of these companies kind of coming into flux, the ancillary components of the industry start to be built out as well. So, for example, payment rails, right? Those are being massively, massively sought after by a lot of different companies that were in the traditional payment space, but now are realizing and understanding, okay, I have regulatory clarity. It's a cheap and cost effective way for me to offer services to my clients. Oh, and by the way, I know that I can communicate with the CFTC on this and actually have some clarity in relation to that.
Absolutely. I mean, sending money anywhere in the world is about to get a lot cheaper from the U.S. Absolutely, for sure. What's your view? What's your personal stance? I mean, one can already foresee a little bit your opinion, but there's this hotly contested debate between the U.S. banking industry, stablecoin people who have stablecoin deposited somewhere, say, an exchange or whatever, shouldn't be able to receive yield from that. It breaks the singleness of money, and so on and so forth. The banking industry says, it says that, and also says, it's not. We have to provide in order to provide yield. We must provide a lot of regulatory rules around that and how that works, and nobody else should have the right to come along and do the same without all the constraints and regulations and so on that we have to comply with. At the same time, well, the industry has been doing this for a long time. I think when I say the industry, I mean DeFi, right? The digital asset space. There's a strong argument that it doesn't benefit anybody to, or at least doesn't benefit the consumer, right? To impede that. I mean, that's just a short reflection. What's your view on this?
Yeah, absolutely. I think that the limitations that they're trying to implement from a traditional financial sector perspective are actually not beneficial at all, in my opinion, in relation to accessing the actual products, because the underlying motivation traditionally has been consumer protection. But the reality is that staking, for example, staking as a service is like a really good example of a economic opportunity for individuals that might not necessarily be qualified to invest in private equity to be able to access. And if it's done in a compliant manner, I just think that there's a middle ground as opposed to kind of taking this more adversarial approach where they're saying, oh, you know what, we need to protect the public at large in relation to these investment products. I think that's a bit of a facade in their attempt to control the assets and the yields specifically, because yield, right, is a traditional banking game that's been around for a very long time. And traditionally, consumers don't really benefit from that. And the banks do massively, right? And they control the assets in that context. And in no way, shape, or form am I advocating that newer companies that are compliant and regulatorily communicative with the CFTC, for example, shouldn't have the opportunity and they should go through proper AML, KYC, and so on and so forth. But I do think, going back to your comment about the DeFi side, that is blown out of proportion in certain circumstances, because a lot of the controversies associated with that were on the decentralized side, right, of stablecoins, for example. So it seems kind of counterintuitive to say, oh, because of things like the collapse of USDT and Terra Luna and so on and so forth, that therefore we can't have compliant access from a consumer perspective to traditional stablecoins that have one-to-one backing. There is reserves, depository requirements, so on and so forth. That it just seems counterintuitive in that context, and ultimately, I think just hurts the consumer because it shifts that potential profitability just back into the hands of the traditional financial institutions. Again, I think the Clarity Act is kind of a great example of being able to bring both those parties to the table and say, listen, banking, you can leverage your traditional licensing in order to enter into this space in a compliant manner. Oh, okay. New fintech companies, more kind of cutting edge businesses that maybe didn't have that licensing, now have a clear path at both state and federal opportunities from a licensing standpoint. Now let's have the market be competitive and let's see where the consumers actually follow. And I think that's a really kind of what is embedded in hopefully the Clarity Act and some of the strategies behind the congressional legislation. But definitely from a controversial perspective, there's a power grabbing component going on with the traditional finance sector.
Understood. We have run out of time, and thank you so much for being with us, Andrew. Andrew Bull from Bull Blockchain Law. Very knowledgeable, very expert, very reputed lawyer in the US. Thank you so much for being on the show.
Thanks for having me. Appreciate it.
Take care. Bye.